Good morning, all. Thank you for being here, and go ahead and start the clock on my opening statement. In today's economy, nearly everyone leaves a digital footprint. Even if you made a concerted effort to avoid smartphones, laptops, and social media, although I have not found that person, you would have a difficult time keeping your personal information from being held in an electronic database somewhere. Consumers should have the peace of mind that their data is protected in a responsible way. But with all types of nefarious activities online, cyber criminals are finding new ways and, frankly, seem to be very consistent in their wishes to steal data. So in the event that our personal data becomes exposed, we need to be able to trust that the companies in possession of that data will notify those affected of the exposure. And certainly it is those companies' best interest to notify promptly and clearly in order to preserve a trusting relationship with their customers. Given these considerations, the question before us is, what are the rules of the road for companies that experience a breach in their data stores? Currently, the laws that govern data breach notification are a patchwork of state and territory-specific statutes. Unfortunately, they tend to differ from each other in many ways. For example, while a number of states have adopted a common definition of personal information, even more states have adopted alterations to that definition, and those vary unpredictably. The definition is important because it triggers the duty to notify of a breach. 3 states include encrypted or redacted data in the definition of personal information, whereas the rest do not. 5 states include records in the definition. Meanwhile, 4 states protect an individual's date of birth and mother's maiden name as personal information. With at least 48 of the various states and territory-specific laws on the books, you can see how the cost of compliance could add up. The global price tag of cybercrime has been calculated around $110 billion annually, and we should not add unnecessary compliance costs on top of this. Adding to the confusion, these laws also tend to vary on the number of days that can elapse after a breach before notification, as well as the method of notification. Even small breaches can cause a compliance headache. In one recent example, a large company experienced a breach where the personal information of just over 500 consumers was compromised, in comparison to other breaches involving tens of millions of consumers. While this may seem small, yet it turns out that those 500 customers lived in 44 different states and therefore had to be notified pursuant to 44 different sets of rules. We must remember that where a breach in data is an intentional intrusion from the outside, for example, if it is done by a hacktivist, a foreign agent, or a run-of-the-mill criminal, the company is holding the data is also a victim. Burdening these entities with overly complicated notification rules is not a solution to the harms that result from the exposure of that personal information held by the company. And with that, I look forward to hearing the testimony of our witnesses and learning about whether or not we can improve the current legal landscape for breach notification. And at this point, I will yield back my time and recognize the ranking member, Jan Schakowsky, for her statement.
Thank you, Mr. Chairman. Apropos of this hearing, it has just been reported this very morning that Anonymous claims to have hacked into 1,800 email accounts of members of Congress and their staffs. So that's apparently in the news. I don't know to what extent that's been confirmed. So I look forward to hearing from our witnesses about this issue and steps that can and should be taken to address it. As a longtime consumer advocate, I believe that the public does have a right to be informed if their personal information, such as names, email addresses, passwords, home addresses, health and financial data, is compromised. As more and more information moves online, it's equally important to ensure the precautions are taken to keep that data secure. Less than 2 years ago, following the breaches of data at Citicorp, Epsilon, and Sony, a report of the data security firm Protegrity found that personal information was, quote, highly valuable, unquote, to cyber criminals, but, quote, vastly unprotected, unquote. Since then, it seems to me, and you'll set me straight, little has changed. Last year, 680 confirmed data breaches compromised almost 28 million records. Many of those could have been prevented with relative ease had the entities holding the data followed known best practices. This is clearly a major issue, which the private sector has not done enough on its own to address, and one of great concern, I believe, to the public. Almost every state and territory, including my, let's see, what is this? Okay. Almost every state and territory, including my home state of Illinois, has adopted data breach standards. While national standards might be needed to adequately address this issue, I want to make clear my view is that any federal law should not weaken strong state laws. In addition, any federal response should establish a baseline so that every American can be assured some level of data protection, not just notification after the fact. This subcommittee has several questions to answer as we consider data breaches and hopefully data security as well. What specific measures should be taken to protect personal information stored online? When should consumers be notified of a breach? What role should the federal government play in ensuring that those steps are taken? I believe that entities that store important data should act proactively to defend that information, and that consumers should be notified if a breach could result in personal harm. The Data Act, introduced by Mr. Rush and passed by voice vote just 4 years ago, would have taken those steps to protect American consumers. I was a co-sponsor of that bill along with Mr. Barton, and I believe it should be the framework for bipartisan legislation in this Congress. Again, I look forward to hearing from our witnesses today about what can and should be done to address breach notification and data security. I hope that this subcommittee can work constructively toward a bipartisan solution to this major issue that impacts all of us. Thank you. I yield back.
And that is our goal. This time the chair recognizes the Chairman Emeritus, Mr. Barton.
Thank you, Mr. Chairman, and I'm very happy that you're having this hearing. As Congresswoman Schakowsky just pointed out, this is an issue that is not unfamiliar to the subcommittee or the full committee. Going back to my tenure as chairman, 2005 and 2006, we passed a bill out of committee, but it didn't go to the floor. Under Mr. Dingell's chairmanship and Mr. Waxman's chairmanship, again, we passed bills that came out of committee, and we've even had one bill that came out of past the floor of the House, but it wasn't taken up in the Senate. The last Congress, we passed a bill out of this subcommittee, but it was not taken up at full committee. So this is an issue that we all have general agreement on, as Congresswoman Schakowsky has pointed out. It's not a partisan issue. Hopefully under your leadership, Mr. Chairman, and Mr. Upton's leadership at the full committee, we'll pass something in this committee on the floor and get the other body to take it up. This year alone, or last year in 2012, there were 470 breaches that meet the definition. And so far this year, they've been 326 breaches. This is an issue that is not going to go away. It would appear to be obvious that we need a federal bill instead of a patchwork of state bills. And I would agree with what Congresswoman Schakowsky said, that a federal bill should be a baseline bill and not a bill that limits the states. With that, Mr. Chairman, again, thank you for your leadership. I believe you're the man who can make this happen, subcommittee, full committee, floor, and then with the other body. And that I'll yield.
No pressure there.
Whoever
you can control half of what you said. Are there any other Republicans on this side that wish to have time yielded?
If not, Mr. Chairman, I yield back to
Then we'll yield back. So before I announce our panel and start our testimony, an announcement of sorts. Oh, Henry here's. So while he's sitting down, my announcement is we will recess at noon and reconvene if we're still necessary to. I have a feeling that there's going to be enough questions that we'll reconvene at noon, at 1 o'clock. But break for noon. And I recognize the full committee ranking member, the gentleman from California, is recognized for 5 minutes.
Thank you very much, Mr. Chairman. I welcome all of our witnesses today. Our subcommittee is going to address the federal role in data breach notification. It's alarming just how common data breaches have become. Since 2005, at least 600 million records containing consumers' personal information have been compromised as a result of more than 3,800 data breaches in the U.S. At least 72 million personal records have been compromised only in the time since July 2011, when the subcommittee last considered this issue. Every type of entity has proven vulnerable, including private sector companies of all sizes, colleges and universities, and federal, state, and local governments. Breaches result from a wide variety of causes. External criminal attacks, dishonest insiders, and simple negligence can all be responsible for compromising consumers' personal information. Moreover, in recent months, it's become abundantly clear that commercial data breaches can also result from state-affiliated cyber attacks. Consumers face severe threats to their financial well-being when data like banking information or Social Security numbers are compromised. In 2012 alone, more than 12 million U.S. adults were victims of identity theft or similarly costly forms of fraud. Less reported, but also of concern, is when breaches, non-financial in nature, threaten consumers' privacy, including breaches involving health-related information, biometric data, or a person's precise location. Nearly all U.S. states and territories now have laws that require notice for their own residents when a data breach occurs. These laws vary greatly, but several people are quite strong, several of these laws are very strong, ensuring that consumers receive prompt, clear, and complete notification when their personal information is breached, and providing them with the resources to protect their financial well-being. I'm glad these laws have been enacted, but after the fact, breach notification is only half of what is needed. The private sector also must take responsible steps to safeguard personal information. When it comes to information security, prevention is the best medicine. Research shows that the vast majority of attacks on commercial data, 78% according to Verizon Risk Team, utilize simple tactics easily thwarted by basic security infrastructure and procedures. There are many companies that take information security very seriously and work diligently to combat this problem, and perhaps there will always be cybercrime. But unfortunately, there are also companies that are not doing enough to prevent breaches, and consumers are paying the price. As the subcommittee moves forward with its work on information security, I strongly encourage all members to keep 2 points in mind. First, federal legislation must not move backward by undermining those states with strong breach notification laws. And second, effective security for consumers' personal information indisputably requires both breach notification and reasonable safeguards for commercial data. I look forward to the testimony we're going to get today and our discussion of these issues today and in the future, and I hope we can work together to deal with this important issue.
Yeah, appreciate that, Mr. Waxman. This time I'm going to introduce our full panel, and then we'll start with Mr. Richards. But Mr. Richards is the Senior Vice President of Federal Government Affairs for Tech America. We have Dan Ludicus. Did I pronounce that correctly? Thank you. Chief Legal Officer, CompTIA. We have Mr. Jeff Green, Senior Policy Counsel, Cybersecurity and Identity, Semanity Corporation. We then have Debbie Mattis, CTIA Wireless Association, Vice President of Privacy. We have Andrea Matwishin, Assistant Professor of Legal Studies and Business Ethics at the Wharton School, University of Pennsylvania. David Thaw will complete our testimony, and he's visiting Assistant Professor of School of Law at the University of Connecticut School of Law. You will see little lights down there. Green means go. At 4 minutes, the yellow light will come on, and that should be a sign to, if you've got a full page or two left, you may want to skip to the conclusion. Red light means I'm going to lightly tap the gavel. And so I appreciate keeping it to the 5-minute mark, especially since we have been kind of put on an awkward, tight schedule today. So, Mr. Richards, you may begin. You are recognized for your 5 minutes.
Thank you. Mr. Chairman, Ranking Member Schakowsky, and distinguished members of the subcommittee, thank you for the opportunity to testify today and for convening this hearing on the important issue of data breach notification. I'm Kevin Richards, Senior Vice President of Federal Government Affairs of Tech America, a leading technology association representing the world's premier technology companies from the information and technology communications sector at the state, federal, and international level. The topic of today's hearing is an issue of great concern to our members who view the unauthorized disclosure and use of personal information as a threat that erodes public confidence in a connected world. Tech America's member companies understand better than anyone the nature of cyber threats that America faces today and what must be done in order to protect consumers' information from data breaches. The rapid growth of the collection of information in electronic form has provided consumers, businesses, and governments with tremendous opportunities, from revolutionizing the way medical care is provided, to enhancing government services, to enabling a free internet with more opportunities appearing daily. However, this collection of data has also resulted in a concomitant exposure of companies to risks and liabilities arising from the collection, use, storage, and transmission of information, particularly sensitive information about individuals. Tech America strongly believes that if a breach occurs that poses a significant risk of serious harm, that there should be a consistent national policy to ensure that customers and consumers are notified in an appropriate manner. Today, 48 different state jurisdictions in the U.S. have data breach notification laws, and while many businesses have managed to adapt to these various laws, a properly defined data breach notification standard would go a long way to guide organizations on how to address cyber threats in their risk management policies. It also would help prevent breaches and give guidance on how best to respond if an organization should fall victim to a breach caused by an attack. It would be particularly helpful for smaller businesses, many of whom cannot afford teams of lawyers to navigate 48 breach standards should something bad actually happen. National data breach legislation should be carefully crafted and in particular be technology neutral to help organizations prevent and respond to security incidents while avoiding costly, burdensome rules that would not provide any real protection to consumers and freeze security innovation. Such legislation will provide much-needed regulatory relief to companies facing conflicting legal obligations under today's patchwork of state laws. Tech America has been a leader in calling for a strong preemptive and uniform national breach notification law, federal legislation that promotes notification to consumers when their data has been compromised is needed and can effectively help restore consumers' online trust and confidence. The first objective of federal data breach notification legislation should be to establish a uniform national standard and preempts the current patchwork of existing state laws while providing a safe harbor for those entities that take steps to protect their systems from breaches and render data unreadable, undecipherable, and unusable in order to protect individuals from harm. The following recommendations are a result of lessons learned from the implementation of regimes by the current 48 different state jurisdictions in the U.S. and would serve as a good benchmark for drafting potential legislation. 1, legislation must establish a single uniform preemptive standard. 2, a meaningful threshold for notification should be established. 3, define carefully the kind of personally identifiable information that is covered by notification requirements. 4, avoid mandating specific technologies while encouraging the adoption of good practices. 5, why third parties manage data and notification is required, avoid consumer confusion. 6, a federal law should do more than the patchwork of state laws to protect consumers. In conclusion, Tech America believes that the patchwork quilt of state laws and existing requirements need to be overhauled by a uniform preemptive national standard based on the risk of harm. This would be effective addition to the significant protection consumers receive today. With the Chairman's permission, Tech America would like to request the submission of Tech America's national data breach legislative principles for inclusion in the record for today's hearing.
Unanimous consent to allow. Hearing no objection, so allow.
Thank you. We are happy to offer assistance to the committee and work with you as the legislative process moves forward. Thank you for allowing me the privilege to appear today in order to share Tech America's views on the important issue of data breach notification. I'd be happy to answer any questions that the committee may have at this time.
Thank you very much. And now, Mr. Liticus, you have your 5 minutes.
Good morning, Chairman Terry, Ranking Member Schakowsky, and distinguished members of the House Subcommittee on Commerce, Manufacturing, and Trade. This testimony is submitted on behalf of the 2,000 members of the Computing Technology Industry Association, also known as CompTIA, a not-for-profit trade association. CompTIA is also the leading developer and provider of vendor-neutral education, IT workforce certifications, including A+, Security+, and Network+, and organizational credentials such as the Security Trust Mark. My name is Dan Liticus, and I am the Chief Legal Officer of CompTIA. Prior to CompTIA, I was an attorney in private practice focusing on corporate, technology, and intellectual property matters, primarily for the small to medium-sized business. I'm a native of Chicago, Illinois, and was born to immigrant parents from Lithuania. My father opened his own television repair shop and then later started a construction business. My mother started her own restaurants, delis, and banquet halls. Both lived the American dream by being entrepreneurial and starting their own small businesses. From my own experience, I submit that small business owners don't want handouts. Like the businesses started by my parents, many of our members are small to medium-sized businesses, except that they are IT solution providers that help other small to medium-sized businesses set up IT systems and manage data. They also just want a fair shot at pursuing the American dream. In the context of today's hearing, that means eliminating unnecessary barriers to entry, such as redundant and burdensome regulations. With that context, let me state up front that our membership supports a federal approach to data breach notification. It is hard to believe that it has been 10 years since California became the first state in the country to enact a state data breach notification law. Today, there are 46 states, D.C., and several territories that have enacted data breach notification laws. Data breach notification standards are clearly a relevant concern for millions of users sharing information through the internet and for information being stored in various forms. A federal approach will bring clarity and certainty not only to small businesses, but also to consumers who may not be aware of the notice obligations of a particular state's data breach notification law, or even when such obligations may apply. We appreciate the opportunity to submit our written testimony that provides greater detail on the burdens of the current patchwork of state laws and the way in which advancements of mobile technology exacerbates those burdens. Therefore, I would like to spend the balance of my time on the solution. Based on our collective experience and outreach efforts, we believe that the IT industry will be receptive to a national data breach reform framework that contains the following 6 principles. Number 1, there should be a single national federal standard for data breach policy. Businesses which conduct commerce over multiple states need the certainty and efficiency that a national standard would provide. Number 2, Congress and the FTC should not mandate specific technology or methods for data security practices. The environment for data security is constantly evolving, so any regulation should focus on promoting validated industry standards for security rather than a single, quickly outdated solution. Number 3, there should be an exemption from notification requirements for entities that deploy technology or methods such as encryption and other technologies that render data unusable or unreadable by hackers as a harm prevention measure. Number 4, all enforcement and penalties for data breach law should be administered by a central government agent instead of state attorneys general, except in cases where the federal agent can and has not acted. Number 5, entities compliant with existing data breach legislation, such as the Gramm-Leach-Bliley Act, should be exempt from new regulation. We should not reinvent the wheel or create conflicting or overlapping regulations. And number 6, notification should occur on a reasonable time frame, which includes allowances for risk assessment and any necessary law enforcement procedures or investigation. Notification should be focused on events where there's a possibility of actual harm, including a minimum threshold of affected individuals. In closing, I want to reiterate that we believe that a national data breach framework is in the best interest of both consumers and small to medium-sized businesses. Thank you again for the opportunity to share our perspective on the issue of data breach notification reform, and I look forward to our discussion on how to best approach this issue, and I'll be happy to answer any questions.
Thank you very much, Mr. Green. You are now recognized for 5 minutes.
Chairman Terry, Ranking Member Schakowsky, members of the subcommittee, thank you for the opportunity to testify today on behalf of Symantec Corporation. We're the largest security software company in the world with 31 years of experience in developing internet security technology. For organizations that have critical information assets, the risk of a data breach has really never been higher than it is now. We estimate that last year there were 93 million identities exposed. Thankfully, few of these victims will have his or her identity stolen or bank account raided, but the reality is that all of them are at risk for it, because once your information has been stolen, you can do little more than hope that no one tries to monetize it. The cost of these breaches is real. Mr. Chairman, as you mentioned, in 2012, our Norton Cybercrime Report put the global price tag of consumer cybercrime at $110 billion, and that's just the consumer side. On the business side, the Ponemon Institute estimated that in 2012, the average organizational cost for a breach in the U.S. was $5.4 million. Breaches can be caused most commonly or very commonly by lost computers or portable media, and they can be caused by outright theft. People who walk out the door with sensitive information, disgruntled or fired employees. But there is another cause for breaches, and that's targeted attacks. And actually last year, according to our Internet Security Threat Report, 40% of breaches were caused by targeted attacks and hackers. Most of these attacks rely on social engineering, basically trying to trick people into doing something on their computer that they would never do if they were fully cognizant of their actions. We also saw a lot of email attacks. It's still a very common vector. And we regularly see criminals mining social media to come up with tidbits about individuals they use to craft emails that will look legitimate even to very cautious users. 2012 also saw the emergence of what we call watering hole attacks. Like the proverbial lion in the jungle who waits by the watering hole for unsuspecting prey, cybercriminals have become adept at compromising legitimate websites and then sitting on them and waiting for visitors to come by and then attempting to compromise everyone who visits. The growing use of the cloud also presents unique challenges and opportunities. Cloud done right is an opportunity for very strong security. You're putting your data behind higher walls and having it watched by more eyes. Cloud done wrong, though, can be a recipe for data breach because you are grouping your data with many other people's, creating a very desirable target for attackers and one that's not well defended. As you mentioned, Mr. Chairman, mobile devices require strong security. We're all doing more and more of our lives on mobile computers, and unfortunately the criminals are following. Last year we saw a 58% increase in the types of mobile malware that were designed, the types of malware that were designed specifically for mobile devices. And even since we released our report in April, we've seen dramatic evidence of the increasing focus on mobile attacks. Good security really starts with the basics: patch management, updating your patches on your computer, and strong passwords. The breach that the ranking member indicated was reported this morning. Based on the early reporting, there were a significant number of people who were using the word password as their password. That's just not a strong password, and you're asking for it. So-called 0 days or previously unknown critical vulnerabilities receive a lot of media attention, but unfortunately it is still well-known older vulnerabilities that caused most patches. Modern security software is essential. I'm not talking about the proverbial your father's antivirus anymore. Modern security software will monitor your computer looking for anomalous internet activity, processes, or other system events that could be indicative of a previously unknown infection. We have reputation-based technology we use that actually looks at individual files based upon their frequency we see out in the wild, and we're able to detect previously unknown threats just by looking at a file that way. Looking at the legal landscape, we do support a national standard for breach notification, and we have identified 3 principles that are key to us. First, the scope of any legislation should include all entities that collect, maintain, or sell significant amounts of records that contain sensitive personal information, and we think that that should apply equally to the government and to the private sector. Second, pre-breach security measures should be central to any legislation. New legislation should seek to minimize the likelihood of a breach, not just focus on what to do afterward. And finally, any notification scheme should minimize false positives. Promoting technology like encryption as a best practice would significantly reduce these false positives and limit the burden on consumers and on businesses. I thank you again for the opportunity and the privilege to testify today. I look forward to your questions.
Thank you very much, Ms. Matties. You're recognized for 5 minutes.
Chairman Terry, Ranking Member Schakowsky, and members of the subcommittee, thank you for the opportunity to participate in today's hearing. My name is Debbie Matties, and I'm the Vice President for Privacy at CTIA. CTIA, along with AT&T, Comcast, DirecTV, NCTA, Time Warner Cable, U.S. Telecom, and Verizon, is a member of the 21st Century Privacy Coalition. The coalition seeks to modernize U.S. privacy and data security laws to better serve consumers, as well as to reflect the ways that communications technology and competition has changed in the last 2 decades. CTIA commends the subcommittee for exploring whether federal data breach legislation is necessary to protect consumers. Today's patchwork of state and federal data security and breach notification laws is complicated for businesses and provides uneven protection for consumers. A strong, comprehensive, and streamlined federal framework enforced by a single agency would create more certainty for businesses and better protect consumers from the harms associated with data breaches. Today's variety of state and federal requirements creates inconsistent, sometimes contradictory responses to breaches that do not benefit consumers. For example, some states require breach notifications to occur, quote, without unreasonable delay, whereas other states require specific timeframes for notification. Some states provide an exemption from notification for immaterial breaches, whereas other states do not. Most data breaches impact consumers in multiple states, just like the breach that happened here in the House. And electronic data is rarely segmented by state. So under current law, the question becomes, which state law should apply? The state in which the consumer resides, the state in which the breach occurred, or the state in which a vulnerability existed and was exploited? For wireless consumers using family plans, often the user of a device is in a different state from the subscriber who pays the bill. Given the fact that breaches inevitably transcend state borders, a federal approach to breach notification is appropriate so that all consumers receive the same benefits. The absence of a consistent nationwide regime also creates unnecessary distraction for companies that need to stop a breach, evaluate the damage caused by the breach and its scope, correct whatever vulnerability resulted in the breach, work with law enforcement to investigate the breach, and of course, most important, notify consumers to help mitigate any harm. These time-sensitive activities are hampered when a company, especially a small business, has to evaluate which of the 48 different state regimes applies to each of their customers and then tailor breach notifications accordingly. It also makes it difficult for consumer protection agencies, consumer advocates, and businesses to educate consumers faced with a data breach about their rights. Multiple federal regimes undermine consumer protection in a similar manner. For example, wireless carriers fall within the FCC's CP&I rules to the extent they are providing a telecommunications service such as voice. But some providers of voice, like Skype, are not subject to CP&I rules. And then the FTC asserts data security jurisdiction over wireless carriers when they are providing internet access. In any case, the CP&I rules don't really make a lot of sense. They don't cover critically important information like name, social security number, or credit card number, but they do cover, for example, the number of voice lines a subscriber has on her plan. A unified, streamlined federal data security and breach notification law that applies equally to all entities and to all data would make consumers more confident in the security of their online information and would in turn give them greater trust in internet commerce. This unified federal approach to data security is bipartisan and is in line with the Obama administration's recommendations to level the playing field for companies and provide a consistent set of expectations for consumers by simplifying and clarifying the privacy laws. CTIA supports the administration's recommendation to narrow the common carrier exemption to the extent needed to enable the FTC to enforce data security and data breach notification requirements. Mr. Chairman, CTIA fully supports a unified, streamlined federal data security and breach notification law that is enforced by the FTC and benefits consumers who expect that their information will be afforded the same high degree of protection regardless of what entity collects the information, where the consumer lives, where a breach occurs, or where hackers may be trying to access personal information. Congress should enact a new law to better reflect consumer expectations. Be happy to answer your questions.
Well done. Professor Matwischen, you are now recognized for 5 minutes.
Thank you. Chairman Terry, Ranking Member Schakowsky, it's my great honor to be with all of you today to discuss a topic that I've devoted my scholarship to, and that is the question of how to improve information security in the United States. I started working in this space approximately 14 years ago as a corporate attorney representing multinational clients as well as entrepreneurs in Chicago. I've really watched the evolution of this space as both a member of the business community at first representing clients and now as an academic. And although there's been tremendous improvement in this space, we still have a reasonable way to go. The public awareness around questions of information security has tremendously increased during the last 10 years. And it is with great pleasure that I see that we're discussing these topics today. However, the questions of conduct and reasonableness in behavior and information security still remain unanswered. With that, I'd like to offer a historical example, to offer perhaps a paradigm to conceptualize questions of information security. In addition to teaching internet law and data security and privacy law, I also teach securities regulation. And I would submit that perhaps the questions that we're facing today have a historical parallel in the questions that this Congress faced when thinking about balancing the interests of consumer protection, capital formation, and market stability in the 1933 and 34 Acts. Today, in this context, perhaps those three elements are consumer protection, economic stability broadly in terms of securing information and preserving sectors of our economy that rely on information flows, and facilitating responsible innovation. So with those three elements, we can take a look at the broader set of questions in information security. And I would submit that perhaps we should draw a clear distinction between disclosure regulation and conduct regulation. Disclosure regulation, specifically data breach notification statutes, have developed to a high degree on the state level. We've had states function as the laboratories of experimentation, and the state statutes have shown us the way as to what is a feasible and successful approach for disclosure, and offered us guidance to, at this point, be able to come up with a set of criteria that can be operationalized on a national level through the Federal Trade Commission to provide us the data to be able to analyze what's going on in our economy, who are the companies that are behaving with best practices, and who are the companies that are not yet quite up to par and need to be encouraged, regulatorily or otherwise, on the state or national level, to improve the quality of information security that they implement throughout their organizations. The written statement that I've submitted offers a framework of this nature. Conduct regulation, I would submit, we're not ready to really focus in on with a national framework yet. We need the states to show us the way, the same way that they did in the context of data breach notification. Let the states experiment, guide us, discover what works, what doesn't work, and then perhaps we can revisit this question. I would respectfully urge this body to allow for this state experimentation and to preserve the right of states to determine recourse appropriate for their consumer harms. While disclosure legislation deals with purely providing information to empower consumers to make good choices, conduct regulation is the place where we contemplate harms. This distinction, I think, would be fruitful to operationalize into a national framework for data breach notification harmonization. And in my last minute, I'll highlight some of the elements that I elaborate on in detail in my written statement that may provide guidance for a federal harmonized framework. First, the concept of information from a consumer and from a corporate perspective does not map onto the notion of PII that we've been working with. sometimes the most innocuous bits of information can be the most important. If I use my favorite flavor of ice cream as my security question for my bank account, that is perhaps my most sensitive information. And so I would suggest that perhaps we should reconceptualize our notion of what constitutes consumer information in line with the way that sophisticated companies treat information, and that's around information that is shared by a consumer in a trusted relationship. And with that, I will conclude because I'm running out of time, but I would request that this committee turn to my statement and examine the framework that I've proposed. Thank you.
We will. Appreciate you submitting that. Professor Thaw, you are recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Terry, Ranking Member Schakowsky, distinguished members of the subcommittee, I am David Thaw, visiting assistant professor of law at the University of Connecticut and fellow of the Information Society Project at Yale Law School. I appreciate the opportunity to testify regarding the important issues of data security and consumer protection, a subject I have spent the better part of a decade researching and working on professionally. Federal data breach notification is important, but it must be implemented properly. In my oral testimony today, I wish to address 2 core issues relevant to proper implementation. First, whether to address breach notification separate from broader information security regulation, and second, what burden of proof should be required if a risk of harm threshold is adopted for breach notification. I understand the subcommittee to be taking up the issue of data security, beginning with the question of breach notification separate from comprehensive information security regulation. I caution against this approach for 2 reasons. First, comprehensive information security combined with breach notification is substantially more effective than is either regime alone. As part of my research on information security regulation, I compared the efficacy of these 2 regimes. Specifically of note to the subcommittee's agenda, the combination of the 2 was nearly 4 times more effective at preventing incidents than was breach notification alone. I analogize the effects of breach notification alone to locking the bank or vault door while leaving a back window wide open. Second, approaching the issue of breach notification separately requires establishing certain information categories. For example, defining what information to protect is essential to breach notification. This definition, however, has a different purpose when considering comprehensive information security. Furthermore, once established, these definitions will be difficult to change. The burden to business, for example, to reclassify information for compliance with multiple definitions is substantial. To be specific, the types of information that should trigger notification differ from the types of information that should be protected overall. For example, medical records, wills, personal diaries, sensitive or private photographs, and other similar information are all items federal law currently recognizes as sensitive personal information. State law has more narrow definitions, including Social Security numbers, financial account numbers, and government ID numbers. Consumers should be informed about unauthorized disclosure of all this information. By contrast, sensitive information about trade secrets, computer infrastructure, or for security measures is not the province of the general consumer, yet such information must also be secured. On these bases, I strongly recommend that the subcommittee address breach notification and comprehensive data security concurrently. The second issue I wish to address is the risk of harm threshold. Certain formulations of this threshold negatively impact information security. Specifically, a threshold employing a negative presumption of notification, which requires proving risk of harm before triggering notification requirements, disincentivizes organizations from conducting thorough investigations. Organizations have incentives to limit investigations that might increase their liability. For example, when conducting comprehensive information security assessments, auditing and consulting firms often work together with law firms so that the results will be privileged and thus not discoverable in future civil litigation or regulatory investigations. Clients do not want to incur liability for failure to remediate security vulnerabilities identified in the assessment. A similar analysis applies to breach investigations. My research data supports this conclusion, as does my professional experience. Thus, I strongly recommend that if a risk of harm threshold is adopted, the committee adopt an affirmative presumption of notification where risk of harm must be disproven before notification is exempted. To place the burden otherwise disincentivizes information security investigations, one of the most important tools in protecting consumers against future breaches and securing the overall information security ecosystem. I am happy to offer any assistance to the committee as it moves forward in its work. I again thank the chairman and the ranking member for the privilege and opportunity to testify here today, and I am pleased to answer any of your questions.
Thank you very much for your testimony, and appreciate the two law school professors here. It makes me feel I had flashbacks to law school during your testimony. With that, I'll start the questions, and it was the answer to this is just yes and no, and it was fairly clear in some of the testimonies, but I do want to get it succinctly on the record, starting with Mr. Richards and then going down to Professor Thaw. Do you believe there should be a federal notification law? Mr. Richards?
Yes, we do, Mr. Chairman.
Yes, we do, Mr. Chairman.
Yes, sir.
Yes.
Now we get to the murkier.
Exactly. Yes, provided the standard is at the highest level and does not preempt state law, as well as conduct being carved out to allow for states to experiment.
Yes, provided implemented properly. I provide detail in my written testimony on this and concur with Professor Matwishin's statement.
See, that's what the flashbacks. There's always enough room to screw up on the test now.
It always depends, right?
It always depends. And the reason why I think it was important to just lay that item of foundation is that with 48 states and territories combined already having, at least at the national, multinational level, you have a level of sophistication where they're already in compliance, and then there's a level of concern that a new national standard just creates 49 instead of 48. So that brings us to what Professor Matwishin said in her but, and that's no state preemption. So how does it work without preemption, and who wants to start? I'll go with Dr. Matwishin first, and then anyone else that wants to speak on preemption.
So I actually consulted with a California government official responsible for enforcement, and provided that the framework on the national level provides a comprehensive disclosure regime, and states and their enforcement agencies have direct access to this information as well as consumers, everyone wins, because the information would simply be centralized. So if the disclosure requirements adequately conceptualize the questions that consumers and enforcers want to know, states, I believe, would be happy with a centralized regime, and there wouldn't be a problem. Enforcement, however, because of limitations of resources on the part of the Federal Trade Commission, I believe should remain on the state level.
All right. Mr. Richards, Ludicus, and Green, and Mattis. Quickly, though.
Sure. Well, we believe the patchwork framework of current state laws are very duplicative in some cases, and in a lot of cases don't make sense. North Dakota, for example, requires notice of a breach of name and birth date. So there's different qualifications in terms of PII and what information you should focus on. New York requires notice of security breaches made to 3 separate state agencies. I think federal preemption is important, but I don't think you should undermine strong consumer protections that are currently held and enjoyed at the state level.
Thank you. Mr. Lucas?
Yeah, I mean, at the end of the day, I think we believe that first and foremost that consumers need the notification standard, but in providing that standard, we can also simplify matters substantially for the small to medium-sized business, which the current technology infrastructure allows them to operate in a way that's much bigger than maybe they could have done some years ago. So I think centralizing that notification standard and avoiding having the issue of determining whether or not a variety of state laws applies or does not apply would be extremely beneficial to the small to mid-sized business that simply doesn't have the resources to.
Interesting. All right, Mr. Green?
I would echo what Mr. Richards said, that if you have essentially a 49 standard, you're just creating another box you have to check to ensure that you're doing everything right. If you do have a breach, you're not going to speed the process of understanding the scope of your breach or who you need to notify.
Thank you. And Mr. Matthews, I'm going to actually change the question for you to a more personalized because of your background and experience with the FTC. There's been a suggestion that at least with some of the telecom that the FTC has the experience on data breach and notification in those areas. If there is a national bill, should it include the telecommunications and video with the FTC?
Yes, the FTC has had about more than 10 years of experience working on data breaches and data security cases, so they're well equipped to handle these kinds of cases. And I just like to point out that there's already a model in Do Not Call for consolidating experiments in the states with consumer protection. A number of states had consumer protection laws for Do Not Call in individual states. And when the national standard became applicable, it really made things a lot easier for both businesses and for consumers, because now consumers have a one-stop shop to go and put their name on a list. That would be the similar aspect here.
All right. Thank you very much. And the ranking member, Jen Schakowsky, is now recognized for 5 minutes.
Thank you very much. Mr. Chairman, I just want to acknowledge that as important as this is to consumers, that maybe in the future we could have a consumer witness or two to just talk about some of their experiences. I think it would be helpful to inform our committee. Talking about data breaches, Professor Matwishin, am I saying it right? Okay. Do you foresee potential harms to the development of effective information security laws if Congress enacts certain breach notification provisions without enacting a well-considered data security law at the same time? I know Professor Thaw addressed that. And if so, what would they be?
If I'm understanding the question correctly, I believe that the optimal approach at this juncture is to bifurcate, to divide off the questions of data breach notification harmonization from the questions of the best standard for liability arising from data security breaches.
To separate those two?
To separate those two out. While the states have shown us the way and adequately experimented with notification, the questions of liability, how to craft it, what the standards are, what reasonable conduct is, that is a moving target and still very undeveloped, both from the standpoint of the information security community as a just now coalescing body of experts, and from the standpoint of states having different approaches to consumer protection and the connection to other bodies of law. The Securities and Exchange Commission is starting to regulate in this space. These issues are tied with broader questions of software liability generally. And if we start to regulate too early, we may disrupt existing bodies of law and stifle innovation that is responsible and consumer protection.
Okay, I do want to put the same question to you, Professor Thaw, and see if the two of you are in agreement too.
I agree with Professor Matwishin in the respect that the states have the ability to provide important experimentation. However, I am concerned about the resources that the states have on the technical side. With respect to the legal standard, I agree with Professor Matwishin. They can experiment and provide us with valuable data. However, this is a highly interconnected issue across the entire country, and I do not believe that the states have sufficient resources for enforcement or for simple providing the research and investigation necessary to know what standards would be effective at a national level as opposed to at a state level.
Well, let me get into the issue of data brokers. Most consumers have never heard about data brokers, but there's a several billion-dollar industry that knows the name, address, age, purchasing habits of nearly every American consumer. One company in this industry possesses on average 1,500 data points apiece on each of 190 million individuals in the U.S. and a profit of more than $77 million on this information. So again, let me go to Professor Matwishin. The Data Accountability and Trust Act that we passed as was passed in the 111th Congress, would have required data brokers to submit their security policies to the FTC and allow the Commission to perform or mandate the performance of security audits following a breach of security. What's your opinion on these kinds of provisions regarding data brokers?
In that case, I believe you mentioned it was following a breach?
Yeah.
That would be entirely consistent with the types of proposals that we're considering now for centralized breach notification. The goal is to get as much information about breaches, how they happened, why they happened, the level of security that's in place in a particular organization, to provide the information to both consumers and enforcement agencies to determine which entities are the good actors and which entities are the actors that still have a way to go to improve the level of care.
With just a minute or two, actually less than a minute, anybody else want to comment on data brokers and the role that they play and how they should be regulated? Professor Thaw?
With respect to data brokers, I draw the committee's attention to the fourth section of my written testimony where I identify different levels of criticality, and I would suggest that data brokers are at a higher level of criticality. The reason being that the information they contain, to use Professor Matwishin's earlier example, could be information which is an authentication credential, such as your mother's maiden name or your favorite color, your first pet, something that you use to secure other data that is very sensitive. For this reason, they should be regulated at a higher level, and this is something that cannot be overlooked.
Thank you. And now we recognize Chairman Emeritus for 5 minutes.
Thank you, Mr. Chairman. I'm going to try to give you a little bit of that time back. I think in your questions, Mr. Chairman, we established the panel does support a federal standard for notification. My question would be, does the panel also support going beyond that so that we get into the prevention and the liability issues? Does everybody support a federal law that goes beyond breach notification?
I think that would depend on, we'd obviously have to see the legislation, but I certainly think we should probably change the culture of how our society looks at cybersecurity or information technology and how do you protect the information. Instead of making it an IT department issue, make it a CFO issue and really change the thinking and the approach to how we approach data protection in the country.
I think we also need to look to industry associations like CompTIA, which provides the industry a platform for collaborating on standards and best practices, and their industry credentials, such as the CompTIA Security Trustmark credential, which audits the security practices of an organization. So I think in light of considering options such as that, I think we should also look at the options that the industry can provide as well.
Conceptually, we support the notion of requiring security standards, so you're looking to prevent the breach, not just to mitigate after. And the same thing with the encryption. So if you have a breach, you're limiting the damage that can happen. But as Mr. Lutikis said, there are a lot of existing industry standards that are effective, and any type of standard needs to be very flexible, performance-based. We don't want to be mandating anything specific in statute when we have a very shifting threat environment. So the notion of saying you need to be secure is okay, but if we get into the level of where we're mandating specific types of solutions, I think that could be problematic.
CTIA members and the broader 21st Century Privacy Coalition is interested in talking about data security for sure, but we're happy to see that we're starting with data breach notification.
Okay.
No limitations of liability are appropriate at this juncture. I think we're a little too premature. On the state level, experimentation would be great. A negligence standard perhaps evolving would be a good move. I think we're ready to address breach notification, but I'd be cautious in approaching liability.
Yes, if properly implemented, and I note that respectfully, Ms. Richards, I am concerned with his proposal about making this a CFO issue. While that is appropriate to companies' fiduciary duties under state law, it is not appropriate to the question of negative externalities that would result from breaches in one organization to the overall information ecosystem. I also do concur with my panelists' opinions that flexible standards are important.
I agree with flexibility. Mr. Chairman, I'm going to turn it back, but let me simply say back in the 1930s when we had a rash of kidnappings, the Congress did not pass a kidnapping notification law. They passed strict laws that delineated it was a federal crime if it crossed state lines and empowered the FBI to use every means possible to go after the kidnappers. We're not talking about stealing our children, but we are talking about stealing our identities. And I would hope that this subcommittee and the full committee goes beyond breach notification law. And with that, I give back.
Is the intent. I am going to call on Mr. Barrow, and then we will adjourn. So if you are next in line as a Republican, you can go to the meeting. Mr. Barrow, you are now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for setting the table with your questions. I want to follow up on some of the issues that you raised. You know, privacy is important to me, the right to be securing your persons and papers from state intrusions in the Fourth Amendment. Warren and Brian Dice said that the right to be let alone, the right of privacy, the right most prized by civilized men, I guess we'd say today civilized men and women. I certainly agree with them on that. I guess there's general consensus that the current regime of essentially 48 separate state and territorial jurisdictions regulating this matter in our common market of the United States just ain't working. I think we all agree with that. And there's a general need for some federal guidelines, some federal standards for a uniform law in our national economy. Mr. Richards, Ms. Ludicus, Ms. Mattis, you each talk about the subject of preemption, the need to preempt conflicting state laws. I want to ask the other members of the panel, what is the appropriate scope of federal preemption in this area? Yes, ma'am, go ahead.
I believe the appropriate scope is creating a harmonized disclosure form, but enforcement should be shared in the same way that it is in securities regulation. In the securities regulation context, we have multiple sources of oversight. It's the SEC, state-level securities regulators, other agencies inside states.
Are you proposing a uniform law but shared responsibility with respect to enforcing the same law? So the federal regulator would set the rules and regulations, but the state folks might enforce the same federal law if the federal government isn't devoting enough resources to enforcing its law, the national standard. Is that what you have in mind?
In the same way that securities disclosures happen on the federal level primarily, but a particular state may have requirements in terms of protecting its citizens.
Well, additional requirements, additional substantive regulations and obligations and duties is different from a uniform standard that either the federal prosecutor or the state prosecutor can enforce, the same law, one land, one law. That's a very different matter. And having the right at the state level to enforce a federal standard is different than being able to make your own standard and enforce that in addition to the federal standard. So I want to talk about whether or not there are other folks on the panel who agree with the proposition that federal regulation ought to occupy the field when it comes to the substantive obligations and responsibilities in this area. Mr. Green?
Sir, we would agree that it should occupy the field, but ultimately I think the notion of state enforcement would be acceptable as long as we're talking about a uniform federal standard.
I got you. Professor Thal?
State enforcement concurrent with federal enforcement would be appropriate, and I want to emphasize that in either case, centralized notification and collection by a federal regulator so that we have information on what is going on is critical.
All right. We've had a slight diversity of opinion with respect to who ought to be able to make the rules, but there seems to be a general consensus that as long as we're enforcing the same rules, it doesn't matter which government the cop reports to, if they're enforcing the same law, that there's some sense there. I want to get to the subject of who ought to be the federal regulator. I think, Ms. Mattis, you said that we not only need to have a uniform federal system, but it'll be headed up by the FTC as opposed to, say, the FCC. Does anybody disagree with that on the panel as to which federal regulator ought to be making the rules that we'll be trying to enforce on a consistent basis nationwide? Does anybody disagree with that approach? Professor Thal?
I agree that the Federal Trade Commission is the most appropriate for consumer regulation. However, that should not exempt critical infrastructure providers, which would include telecommunications providers, from regulations to which they would also be subject by their regulators. Those regulators, for example, the Federal Communications Commission, the Nuclear Regulatory Commission, are better familiar with what are the challenges faced by their entities, and if they need to impose additional standards, they should not be prevented from doing so by consumer regulation.
Is it your position that they can regulate in their area of subject matter jurisdictions and should not be able to regulate in the area of consumer protection?
If I understand your question correctly, my position is not that they should be pushing out the consumer regulator so the consumer regulator has no authority, but only that they may and, if necessary, should regulate concurrently with the consumer regulator.
What do other members of the panel feel about that? Mr. Richards, Mr. Ludicus, Mr. Green, Ms. Mattis?
Mr. Bauer, I would say that the FTC, definitely when it comes to consumer information, certainly I think our approach to privacy in this country is somewhat patchwork when you're dealing with HIPAA and the Fair Credit Reporting Act and Gramm-Leach-Bliley. So I certainly think that the current functional regulators also have a good system in place, but the FTC is certainly equipped when it comes to consumer information.
Ms. Ludicus?
I would generally concur with that, although I think we'd have to conduct some further analysis and see what really makes sense at the end of the day. The question right now is somewhat theoretical, but I think overall it makes sense, and we certainly support having a federal agent, so whichever department that is.
Well, my time has run out, Mr. Green. I regret that. But if any of y'all want to follow up on this and supplement the responses that you've given or that others have given on this subject, please feel free to do so for the record. Thank you so much. And thank you, Mr. Chairman.
And I mistakenly used the word adjourn earlier. We are recessing until probably 1 o'clock. Hopefully by 1:03 or 1:04, we're asking questions of you. So thank you for your patience, and we'll see you in 55 minutes. Appreciate you all being back. We are missing Professor Thaw for the moment. Maybe
He went to go fetch a bag. He'll be right
What's
back.
that?
He went to go fetch a deserted bag so that they don't confiscate it. He'll be right back.
Oh, that's important. We will string things out, but we will start with the questions. We have a short time before either votes or the next committee takes over. So we don't want to delay until he comes back, but we will start with other people. Vice Chairman of the subcommittee, you are recognized for 5 minutes.
Thank you, Mr. Chairman, and good afternoon to the panel. To Ms. Mattis, am I pronouncing that? Mattis? What, in your opinion, should be the proper standard for breach notification? Suspicion that a breach has occurred or actual evidence that such a breach has occurred?
Actual evidence that a breach has occurred.
So you would have the higher standard before?
Yes.
Thank you. And number two, should a breach have to result in identity theft or other financial harm to require consumer notification?
There certainly should be consumer notification for identity theft and financial harm, and we're willing to talk to you about the other kinds of harms that might result from a breach of other information.
Do you have suggestions regarding that other than financial harm?
We're still working with our members to talk about this, and we look forward to talking to you as well about it.
Thank you. Are there others on the panel who have an opinion on that? Yes, Professor.
I believe that actual harm should not be required for notification. It serves a function to advise consumers of the occurrence of a breach and also to allow for tabulation and centralization of information about security practices so that we can collectively get a better picture of the entirety of the economy and the behaviors that are happening around information security.
Thank you. Others on the panel? Mr. Richards?
Thank you. Our standard would be that there should be a notification requirement if the breach presents a significant risk of harm to consumers and may perpetuate identity theft.
A significant harm to consumers, which might be a slightly different standard from financial harm, if I'm understanding you accurately. Yes. Professor Thaw.
I believe that notification should at least occur in all cases to a central reporting authority, which could be a federal regulator, that a substantial risk of harm is too high a threshold. I base this on the civil litigation where it was virtually impossible for any case to advance based on those types of claims. And with respect to the types of harm, I believe this requires further investigation, but should not be limited to identity theft.
And if the notification were made to an entity of the federal government, that entity would then in turn determine whether further notification should be made to the consumer?
That would be conditional on whether or not notification had already been made also by the company. I think at least the agency should retain the right to make that determination.
Thank you. Are there other thoughts from the panel? Hearing none, Mr. Chairman, I'm finished with two minutes to go.
Thank you, Mr. Lance. Mr. Harper, you are now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank each of you for being here. And it's a very important issue to each of you, I know, and certainly it is to our country and many businesses. And I'll start with you, if I could, Mr. Richards, and ask you, how would you define a breach that constitutes a reasonable risk of harm to consumers?
Sure. Thank you, Congressman. In terms of a reasonable risk, we believe that data that could be used to perpetuate identity theft, if you were to allow someone to log into or access an individual's account or establish a new account using that individual's identifying information, and we would hold it to that standard.
Okay. So as you define a breach, how do you define a significant risk of harm to consumers?
If there's a risk of identity theft or stealing personal information and using or creating a new identity based on that personal information.
All right. Well, how should we, or how would we define what constitutes a significant risk of harm to consumers? If you were advising us, if Congress did define the type of personally identifiable information that constitutes harm to consumers, is it possible that such a list would keep up with technological innovations?
Yes, sir. I think it's important not to mandate specific technologies. As you know, we need a flexible framework. Some technologies today and best practices can render data useless. And in that case, if a company or an organization is trying to take the right approach and render the data useless, we believe a safe harbor should be granted to incentivize that good behavior if the information is undecipherable. But we need a flexible framework in an effort not to undermine innovation for new technologies that come down the line.
And I know I'm going to mispronounce your name, Ms. Matias? Maddie?
Oh, Maddie's.
Maddie's. Yes. Okay. All right. I'll do my best on that then. If I could ask you a question. My understanding from your testimony is that different data breach requirements apply to different entities, even for the same information. Is there any public policy justification for applying different data breach requirements to the same information?
No, there is not.
Okay. All right. And I'll ask this panel wide, if I could. All of your testimony points out that states have different notification requirements and definitions. Is there a certain time frame post-breach that you believe individuals have a right to be notified? I'd like to know each of your responses on that. And I'll start with you, Mr. Richards.
Certainly. Well, we think there needs to be a little bit of time in order for a company to perform cyber forensics. We don't have a specific position on a specific time frame, but our businesses and their approach is as quickly as possible, and as long as in consulting with law enforcement and others, and we follow up on our due diligence and report it to the consumer as quickly as possible.
All right. Well, how can, following up on that, how can, maybe you can walk me through, how is notification without unreasonable delay, how that really works in the real world?
Well, I think in terms of, if you look at the different state requirements, there's different time frames that are offered. Puerto Rico is 10 days to notify folks. Vermont is about 14 days. Minnesota requires reporting to credit bureaus within 48 hours. So sometimes when you're looking at that condensed of a time frame, you're really trying to figure out the extent of the breach, what has been breached. So I think in terms of those time frames, it's a very short turnaround and a very short fuse. And I think companies want to make sure that they have the right answers before they disclose information publicly, but believe they do have the responsibility to report it to consumers.
Thank you. And I'll ask each of you, is there a certain time frame post-breach that you believe individuals have a right to be notified? If each of you could answer that. And I know we've only got a few seconds left. Yes, sir.
Yes, Congressman, we certainly, and we'll mirror a little bit of what Mr. Richards said. We believe in a reasonable time frame in which to notify. I think it's just important for the exceptions to be made for instances where law enforcement needs to act or other information needs to be gathered so that the correct information is being provided to the consumers. Right. So we don't have an exact timeline which we recommend, but we do recommend having exceptions for those legitimate reasons.
Okay. And Mr. Green, I think I can at least get your response before my time is up.
Sure. I would say that you definitely need to have enough time so the company can determine the scope of what's lost and what wasn't lost. Fix the vulnerability. You don't want to go public and basically hang a target around your neck. Okay. And I would say, though, a rush to report can be bad. Every incident is different. And I think if there's one rule, it's that first reports are pretty much always wrong. I bet with respect to the breach about Congress today, you're going to see what was published today, a week from now, is going to be outdated. It's going to be different. So you need to allow time. It needs to be as quickly as possible, but you need to make sure that you're getting it right. It's better to be right in most cases than it is to be fast.
Thank you. And I believe my time has expired, so I yield back, Mr. Chairman.
Thank you. And now the chair recognizes a gentleman from Texas, of which he is very proud, and will probably mention that, is recognized for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing, and thank to the witnesses for attending. Mr. Chairman, you should know that I got my plug out with all the witnesses as to why they should move to the great state of Texas before we're gavelled in at 11 o'clock, so we're done with that business. At the end of the day, this hearing to me is about two questions. Number one, is federal legislation necessary when data has been breached? If the answer is yes, then what should that legislation look like? In y'all's written testimony, as I reviewed it last night, it appears that federal legislation would help protect consumers, though Mr. Richards raises the point that for some technology companies it is helpful, but not vital. Our two professors were concerned with federal government overreach and taking over what the states are doing pretty well. But I believe this difference raises an important point, that if we pursue legislation, we must carefully draft it to ensure that the federal government doesn't become the 49th entity out there that companies must comply with. We should have a Hippocratic oath for data breaches. Harm's been done, do no more harm. And regardless of the ultimate decision to pursue legislation, consumers expect their privacy, their personal information to be protected. And I know you all agree we must keep them at the forefront of this conversation and debate. My first question is for you, Ms. Mattis. Do you think the existence of 48 different data breach regimes results in breach notifications being faster or slower?
I think it makes it slower. Companies try very hard to comply with all the laws out there, but it certainly is a distraction at best from the other tasks that they need to complete when dealing with a data breach has been discussed by the other panelists.
Anybody else care to comment on that? Faster, slower? All their states? Professor Thaw.
Congressman, I think it makes it significantly. Oh, I apologize.
You'll be up next, Mr. Luke. Professor Thaw, you go first, sir. Great, got your hand up there quickly.
I believe historically it has made it slower, but it absolutely does not need to. It is a very formulaic regime for which procedures can be developed. For example, to analogize to something with which I believe many people may be familiar, LegalZoom, the product that provides you punch in the information, we generate a will or something similar. I could develop today a program that would handle the current jurisdiction's requirements in place.
Okay, Ms. Lukias, you said I want to jump in there, sir, so come on in.
Thank you, Congressman. In addition to making the process slower today. I think the process of actually evaluating all of the different requirements and the laws out there, it also creates more opportunity for not properly reporting under a variety of state laws. So not only does it slow it down, I think there's more opportunity for mistakes to be made as well.
Thank you. Another one for you, Ms. Mattiz. How do wireless companies deal with the fact that states have different definitions of personal information? Can that result in over-reporting in some states? Does it create consumer confusion? And what harm may companies incur if they over-report? And some examples. So basically, over-reporting, confusion, harm, examples.
I'm not sure I have examples for all those questions, but it's certainly over-reporting can be a problem. It's sort of the boy who cried wolf. If you get notices over and over that actually don't pertain to you, you may start to ignore them. But worse, you may actually start making changes to your passwords and closing and opening bank accounts unnecessarily, wasting your own energy. So it's the different state regimes can cause over-reporting, which can harm consumers, and it also certainly impacts businesses in being able to comply with those laws.
It looks like the professor wants to make comments. Ma'am, you're up.
I wanted to play up on that point. The two complaints, I shouldn't say complaints, the two comments that I've heard repeatedly from businesses in their compliance efforts. First, that the regulatory end of this is complicated. Different regulators are required to receive filings in different states. So simplifying the regulatory complexity would be something they would want. The second point that they repeatedly mentioned to me is the definition of what constitutes information that triggers reporting. And they would be happy with a broader definition of the information that triggers reporting as long as it's a bright line. It's clear to them. And so many companies, especially the most sophisticated technology companies, are now erring on the side of reporting because it's simpler. And they don't view it as necessarily a bad thing. They just want simplification and a single regulatory point of contact.
And obviously, when they go public that they've had some data breach, that affects their business because consumers look at a company that's had some data breach, maybe it's having some faults, which is not true, but the bottom line of the market, they get spooked, and so they move their products elsewhere. One more comment, ma'am, I'm out of time. Professor, you're up. One last shot.
If I can just follow up, the other benefit that a centralized point provides is the ability for companies engaging in highest-end security practices to announce that. And so even if they suffer a data breach from a zero-day vulnerability, for example, if they're using the highest-end software possible, then enforcement agencies are going to say, oh, they tried really hard. This is a good company doing the right thing. But if it's someone who hasn't updated their systems in 6 years and that's why they had a data breach, that's a completely different ball of wax.
Yes, I'm out of time. I thank the witnesses and come to Texas. I yield back.
No. Mr. Johnson, you are recognized.
Also no, Mr. Chairman. I'd like to thank the panel for being here today. I spent about 30 years of my professional career before I came to Congress in the information technology field in the Department of Defense, worked as the director of the CIO staff for Special Operations Command, so I certainly understand the complexities of data security and how easy it is for those who are determined to get into it. So with that as a backdrop, do we have any empirical data to answer the question about how quickly we should notify consumers? I mean, do we have any data that tells us after several 100,000 identities are breached, do we know how long before the bad guys start using that information? Anybody on the panel? Mr. Green?
Unfortunately, there is no answer. There are thriving black markets in personal information, whether it's social security number, et cetera, or simply credit card numbers. And it can be a game of roulette whether your card is bought while it is before it goes stale or not. So we don't know how fast. It really depends upon how they're going to use their information. Slightly off point, but there is empirical evidence. The Poneman study from last year found it was looking at the impacts on. And one of the drivers of increased cost was notification too early. What they found is companies that rushed to notify often notified a significant number of people who, once they did their full forensic work, had not actually had their personal information made public. yet the companies notified them, the individuals, many of them went through the trouble of changing passwords, et cetera. The company had to pay for monitoring and other services. So we do know, and again, not discounting the need to notify quickly, but doing it too quickly can drive up costs, both for the individuals and the companies.
Speaking of quickly or not quick enough, do you think that breaches are over or under notified today? Again, for the entire panel, anybody have a thought? Yes, ma'am.
I'd say they're dramatically under-notified. Frequently, they're never discovered, and that's partially because companies, unfortunately, don't always have state-of-the-art security in place. Also, in the public sector, we have the same challenges with security. So I would assume that there are 2 breaches for every one that's reported.
Sure. Do you given that there's a plethora of state regulations that require this, do you think an overarching federal standard lessens the risk of under or over notification?
I think it's heading in the right direction. I think we're improving. We're all becoming more educated about these issues. Companies are becoming more sensitive. There's been dramatic improvement in the last decade. And particularly in industries such as financial services, they're improving, and there's a learning curve happening. So we're heading in the good direction, and I think federal harmonized legislation is a step in that direction.
Okay. Mr. Richards, you noted that the FTC has been relatively active in bringing cases against companies for failure to maintain or disclose their security practices. If the FTC has this existing authority, do we need to address data security in more federal legislation?
Congressman, in reference to your last point, I believe a strong federal preemptive data breach notification law that's broad in scope would cut down on over-notification, certainly. We believe that the FTC does have a lot of jurisdiction within its existing authority, but we believe, given the patchwork quilt of 48 different state laws, that a broad federal preemptive law would be very helpful to our businesses.
Well, I think I know the answer to this next question, Mr. Richards, but can data security and data breach notification be addressed separately, or are they hand in hand?
Well, I think they can be. I would suggest addressing them separately. First, data breach notification, getting some consensus on the committee. I think certainly the conversation around data security is important. I think there should be some focus on what we've been talking about in terms of a safe harbor, how to incentivize companies or give companies some type of guidance on how they render the data useless. So if it is hacked or stolen, you've taken the measures and you shouldn't have to report. So I think certainly as a balance, a lot of the focus has been what happens post-breach, but I certainly think there's some measures that you can take pre-breach and insert in your company's risk assessments.
Great. I think I'm last, Mr. Chairman, if you would indulge me for one more. Mr. Green, you stated that there were 93 million identities exposed in 2012. Does this mean people, their names, their usernames, or their social security numbers? What does identity mean in that 93 million number?
By the way we counted, it was name in connection with social security number, address, one of the following: social security number, address, date of birth, or credit card information. Essentially, information that put together would allow financial fraud or identity theft.
Okay. All right. Thank you, Mr. Chairman. I yield back.
Well done, everybody. And so that concludes the questioning period, which means we're finished, except for a little bit of work here. I ask unanimous consent to include the following statements in the record. One, statement of the Electronic Transaction Association dated July 18th, 2013. Two, a letter from the Credit Union National Association, CUNA, dated July 17th, 2013. A letter from McDonald Hopkins, LLC, dated July 18th, 2013. Number 4, National Retail Federation statement dated July 18th, 2013. These have all been approved by the minority staff. Hearing no objections then, so ordered. No documents to be submitted on your side. Now all of our business is done. And I want to thank all of you. It's been very insightful. It was very stimulating, and we greatly appreciate your time and your testimony, which is your talent. And thank you, and we are adjourned.